As in last part, we have covered till section 5 of the Protection of Women from Domestic Violence Act. So now we will be going to further sections. What is the under section 6? What are the duty of the shelters home? So they have given an aggrieved person on behalf of the protection officer of the service provider requires the person in charge of the shelter home to provide shelter. So they shall provide to the aggrieved person. That is the section 6. Section 7 talks about duty of the medical facility. That means any aggrieved person or in her behalf any protection officer or service provider is requesting for medical facility or medical aid from the any person in charge of the medical facility, they will provide to them. And section 8 talks about there is a provision of the appointment of the protection officer. The state government shall appoint such number of protection officers to exercise power and perform the duty as given under the act. So further we'll go. uh, what is the requirement or the expectation is that preferably the protection officer under the DB Act has to be woman, and the term of condition has to be prescribed by the rules and the laws under DB Act. And section 9 talks about duties and function of the protection officer. So they have clearly given it shall be duty of the protection officer to assist the magistrate in discharge of the function under this act, and also to make a domestic incident report to the metropolitan magistrate or the judicial magistrate first class upon received a complaint of domestic violence, and also to forward the copy of to the station house officer in charge of the police station within the local jurisdiction where there is a allegation of the commission of the domestic violence, and also application of claiming relief, issuance of the protection order also he has to make. Also to ensure that the aggrieved person is provided legal aid, as I said, because under Article 39 capital A of the Constitution of India, providing free legal aid is uh, for everyone has a constitutional right of the person. So under that Legal Services Authority Act 1987, Section 12, there are eligibility for getting free legal aid is given. So woman is one of the fitting in the eligibility criteria. So it is the duty of the protection officer also to provide the like refer the woman aggrieved person to the facilities of legal aid from the legal services authorities, and there are further paralegal volunteers to help. So also it is duty of protection officer to maintain a list of the service provider in any given areas who provide that legal aid, counseling needs, and also these copy of those list has to be forwarded to the metropolitan magistrate or judicial magistrate first class and service providers also. So, also medical examination of the woman, the aggrieved person also, it is a duty of that protection officer to ensure that the medical examination is facilitated, and a copy of the medical report has to be forwarded by him or her to the local police station and to the area magistrate where there is allegation that domestic violation has happened, and also monetary relief also if someone uh, applies under section 20. So so this has been passed. So compliance of that, execution of that also has to be ensured by the protection officer, and all other duty can also be prescribed to them. And the protection officer also have the control and supervision of the metropolitan magistrate is there above the protection officer, and all those duties imposed by the metropolitan magistrate, judicial magistrate who is competent under the act has to be performed by the protection officer in this act, under this act. And section 10 talks about there is a service provider. With regard to service provider, as we know, there are very voluntary organization, non-governmental organization who are registered under the Societies Registration Act or Indian Companies Act of 1956, now new one, Companies Act of 2030, or any law in force. So if they are registered, so they can apply for designation by the state government as service provider. So, in order to provide legal aid, medical facility, financial, and other assistance providing assistance to the aggrieved person who in the domestic relationships allege that the domestic violence has happened. Okay, then a service provider under the clause 2 of the section 10 says that they have a power to record the domestic incident report the moment they are designated and forwarding such copy to the metropolitan magistrate or the judicial magistrate first class and also to the where the domestic violence took place there this protection officer also they can serve that and also aggrieved person can be medically examined and forwarding the copy of such report also is one of the uh, duties or the power they can function under the act. Also, the aggrieved person is provided shelter home or not. And if lodging in the shelter home has happened, so ensuring that report has to be sent to the local police station for safety and other needs and to the local metropolitan magistrate under the act where the domestic violation has been alleged. So that also is the one of the power of the service provider under the act. And as there is a good faith principle which says that the proceeding against the service provider or the member of the service provider should not be started any kind of suits if in good faith mm, they under the discharge of their function under the act they have done something so uh, in order to like stop their harassment. So prevention of commission of domestic violence, if they will do something in that regard, so they have to be protected. Okay, then there are duty of the government, say central government, state government. So they also has a duty. The duty given under Section 11 says that the central government and every state government shall take all measures to ensure that. So, four, A says the provision of the acts are given by publicity through the public media, television, there are FM channels, print media, electronic media. So these are means of communication they have to use to give wide publicity of the provision so that people can be benefited. Also, the government should, including police officer and the member of the judicial services, like judicial magistrate, who are stakeholder here. So they have to be sensitized and awareness training has to be done on periodic basis to them regarding the provision of what is there in Protection of Women from Domestic Violence Act. Now, what are the rules to capacity build and sensitize? So that is one of the duty of the government. Also, effective coordination, as I said, because this uh, uh, like protection of women from domestic violence itself has many stakeholders in this. So and also various department of the government of India, department of the state governments, central governments are involved in giving various kind of services like a home Ministry of Home Affairs will provide the policing other. So then there are other department, Ministry of Law and Justice is there. And so these all ministries and the department who are working for one cause, the Ministry of Women and Child Development, they should have coordination, working relationship. So that way, effective coordination wise also it is government's like responsibility. Like periodic review has to be conducted on those coordination. Also, various ministry wise also protocol are there so, delivery of services in the courts has to be prepared and put in place. They said. So this is the one of the obligation of the those agencies, and also Section 12 talks about more of the application to the Metropolitan Magistrate or the Judicial Magistrate first class under the Act. So what is the procedure? So clause 1 says that an aggrieved person or the protection officer or on behalf of the aggrieved person, any other person may present an application to the Metropolitan Magistrate or the Judicial Magistrate where the domestic violence has been alleged. So then, while passing an order, the Metropolitan Magistrate is also duty bound that he shall take into consideration any domestic incident report which is received by him from any protection officer or the service provider. So also relief short has to be seen, which means any relief for compensation or the damages. So that all has to be taken care of. So compensation or other things also they said pursuant to order, if something is paid then it has to be set up, so it is more of procedural explanation. Also clause 3 says that every application shall contain the particular as prescribed, mean rules are there, so for performers are there, so all has to be in that performer only. The metropolitan magistrate also has to fix the date of hearing, then not ordinarily beyond the 3 day from the receipt of the application by the competent court. And also the endeavor has to be there of the judicial magistrate or the metropolitan magistrate under the act that within the period of 16 days from the date of first hearing, try to dispose of the application. So shall mean must. Okay. So that is what section 12 is talking about. And there is some rules regarding to service of notices and other. So I will not go into this, but counseling, very important part. I will go section 14, counseling, which says that the metropolitan magistrate at any stage of proceeding, if he feels that he can direct the respondent or the aggrieved person, either both of them or the singly or jointly, to undergo the counsel by the service provider from the service provider which are recognized. Okay, and also who has that qualification and experience to get such designation as the service provider, counselor. So they can refer actually, and also there are some welfare experts are there. So that experts help also they are asking. If the magistrate also is considering that the circumstances of the cases circumstances are so that it is not in welfare or the interest that the proceeding has to be conducted in open court, so in camera proceeding can happen. So that also is given under section 16. That is the satisfaction of the magistrate has to be there. And also either party also is desirous also have to have in camera proceeding, not to go in public courts. So they can conduct so. So right to reside in the share household, as I said that because residence part or shelter home part is very important in this, because many of the domestic violence act there is no place to go. And so that's why section 17 talks about every woman in the domestic relationship shall have a right to reside in the shared household, whether there is any like deserving of the right on the title or on the property or not. They have a every entitlement to settle in the share household. So there are section 18 talks about orders, particularly protection order. What is that protection order actually? It is more of criminal justice system, like police has a power to protect and duty also to protect. So that way, the magistrate may, the metropolitan magistrate may, after giving the aggrieved person and the respondent opportunity of being heard, that principle of natural justice of that these parties of getting heard has to be respected by the metropolitan magistrate, and after giving that opportunity and on being prime facie, that means like preliminary it is it's appearing like that domestic violation has really took place, or it is likely that such domestic violation will take place in, so they can pass a protection order, the order in the nature of protection order in the favor of aggrieved person always, and prohibit the respondents, the opposite party has to be prohibited or stopped for committing any act of, so act is doing actively, okay, any act of domestic violence they have to be, they can be stopped from committing, and aiding and abetting, and some other person of the family is doing that, and other respondent is aiding that, helping that, that also, or abetting. So any of the provocations are there, instigating is there, like forcing, compelling person to commission of an act and of domestic violence. So that also can be prohibited, like respondent can be prohibited from doing this all. Also, there are place of employment of the aggrieved person. Aggrieved person might be employed gainfully, and there the respondent may disturb the such aggrieved person. So they can like they can stop the entry of the aggrieved this respondent. And also if aggrieved person is child, then the child goes to schools, uh, goes to park and other playing area. So these all frequented area um, has to be like respondent has to be prohibited from going or trying to do something. Also to attempting to commit any form of personal or a written electronic and telephonic contact, like sending email, contacting again and again through phone, sending emails. These all can be respondent can be stopped from doing that all under the these all protections orders. And also alienating any asset, if there is a property is there, some stridhan, some part is there which is the entitlement of the aggrieved person, or there is a property which where it has to be decided. So for that property has to be secured. That means stopping the respondent from alienating or expunging the right, or not considering the share, etc. So respondent has to can be stopped under the protection orders. Also, there are many dependents of the aggrieved person, like sons, childs, other persons. So causing any kind of physical, any kind of violence to this person or their relatives, or any person who is actively or who is giving support to the aggrieved person to go to the mechanism of complaint to the metropolitan magistrate, protection officer, police station. So if these people are helping the aggrieved person and the respondent, uh, there is likelihood that respondent is will cause the violence to that person. So protection order can be issued by the competent court, stopping respondent from doing all this, or any other acts also specified in the protection order has to be respondent has to be stopped from doing that by the court. So one is protection order. Now we are coming to resident orders. There is one order called residence order. What is this order mean? Now, while application of that aggrieved person, a metropolitan magistrate is disposing of, then when the it is satisfied that the domestic violation has taken place, and then the residence order can be passed. So what all the condition resident order as per the section 19 of the Protection of Women from Domestic Violence Act are, like one is restraining the respondent from dispossessing or disturbing the positions, okay, in the share household, whether there is a right equitable or not, or also directing respondent to remove himself from the such share household. It can be asked when there is a satisfaction that domestic violation has taken place. Also, restraining the respondent from entering any portion of the household, and also restraining respondent from renouncing his right. Then, only permission of the magistrate can empower such restraining. Actually, directing the respondent to secure same level of alternate accommodation when there is very necessary that in that share household it is not livable, then paying asking the respondent to pay the amount of the rent or the similar kind of like accommodations, that also can be asked in the residence order. If there is any in clause B, removing from the household, if there is a woman respondent or anyone. So against her, uh, on complaint of the aggrieved person, she cannot be asked to remove herself from the this share household. So that the law has given protections. So also clause 2 talks about additional condition the magistrate can impose. Also bail and bond provisions are there. So the metropolitan magistrate can ask to execute a bond with or without surety on the basis of the best judgment for preventing the commission of the domestic violence. So that is given under clause 3. And also these orders are order. Okay. Also, officer in charge of the police station like SHO or their station house officer to give protection to the aggrieved person or assisting her, that kind of order can be passed, or an application for implementation of order can also be done. Okay. Also, respondents some obligations can be like imposed, like discharge of the rent and the payment, financial needs, resources that can be done. And also in implementation of protection officer, sorry, orders, the SHO can be directed. And also return of the possession of the stridhan and other property, valuable security which belongs to the aggrieved person only. The respondent can be directed to return those things to aggrieved person by the metropolitan magistrate. There is section 20 talks about monetary reliefs also. While disposing of an application under subsection 12, the magistrate may, mean metropolitan magistrate may direct the respondent to pay some of the monetary relief, like money wise, and or to meet the expenses incurred or loss can be suffered by the person, and any child of the person can also suffer due to that domestic violence. So the metropolitan magistrate can ask for monetary relief from the respondent to the aggrieved person, and such relief shall include and will not be limited by these provisions. In section 20, it says loss of earnings. Like if the person is actively was earning, going to job, and due to domestic violence, that whole opportunity of going, joining employment, reporting to the duties, continuing the work and has been suffered. So loss of earning in actual basis can be asked from the respondent to pay to aggrieved person. The medical expenses incurred during the any medical facility when person is availing which medical this medical conditions is due to domestic violence meted out. So asking for medical expenses so incurred can be done. And also there is some destruction, damage and property also removable is there. So and the aggrieved person may hold some control over these kind of properties, and due to domestic violence the aggrieved person is now dispossessed of such property and the ownership. So the monetary relief includes whatever the loss caused due to that loss of ownership can also be asked to be like return the money or the amount of such. The maintenance for the aggrieved person as well as the children, for that under section 125 in addition to. Okay, because we know there is section 125 of the criminal procedure code which talks about maintenance of wife and children. So in that this DB Act is in addition to that. The it is like metropolitan magistrate may give the monetary relief in addition to section 125. Also, this has to be adequate compensation, fair, reasonable, and consistent with the standard of living which the aggrieved person was accustomed standard of living. And also, the lump sum payment can be ordered, monthly payment of maintenance can be ordered. Also, the order of the copy of the monetary relief has to be given to the police station and the respondent by the Metropolitan Magistrate Court. So to execute, implement. Also, now, okay, then upon failure on part of the respondent to make payment, what will happen then? The employer will be there. The respondent may be under some enterprises, some job. Okay, so the principal employer or the agency which is giving them the salary can be asked to directly transfer such an amount which is fixed by the Metropolitan Magistrate after considering the case. The monetary relief can be directed, or any debtors is there, directly they can be paid or deposit in the courtroom, whatever is convenient. Uh, so then there is some provision with regard to custody orders, because childs are involved always in domestic relationship. So custody is also one of the major litigating factors. So with regard to custody order, section 21 clearly says that others provisions are there. The magistrate may at stage of hearing what he can do, he can order any other relief. That relief is like grant of temporary custody of any children to the aggrieved person. This is one of the custody relief. Or person making an application, some visiting rights. So this can be given. Okay, also, if the interest of the child, like Juvenile Justice Care and Protection of Children's Act 2015 also says that there are certain principles under section 3, I guess. So principles are there. So principle of best interest of the child. If something is in best interest of the child, like JJ Act or Juvenile Justice Board of the Child Welfare Committee will work on those considerations. Similar way, if the Metropolitan Magistrate also, during an application and the trial, if someone has made application and under section 12 is considering, so in that best interest of the child lies in custody or not has to be seen. If by giving the custody to the aggrieved person of the child for temporary or permanent basis, if the interest of the child is served, then it is justified the learned Metropolitan Magistrate Court or Judicial Magistrate First Class Court under the TB Act. So interest of the child is to be seen. And also their compensation order provision is there. Like if the application is made, then respondent can be directed to compensate the damage of any injuries. So they have given kind of injury like which includes the mental torture, like some of the psychological, um, emotional distress caused by that, and also uh, by the respondent. So that is there. Also, because these cases, although there is specific direction that within the 3 days that first hearing and within the 60 days disposal of the application. So many times there is need to have interim or ex parte orders. What is interim mean? Interim is something which is not final. That means while considering these applications, so there is need to pass certain kind of measures to protect the aggrieved person from the respondent. So, while there is no final disposal law, also sometimes the opposite party, respondent party may not appear, or there is a need to have passing ex parte order. Mean if one of the party is absent, the party who is present in presence of one party also, the honorable court can decide the matter. Ex parte order can be passed. So if the all process of serving notice and other thing has been complied with completely. And in any proceeding, the section 23 says that under this magistrate may pass an interim order which is just, I mean justice, fair and proper, like it is proper to pass that if the applications of the facts are stated are right. And also if in prime facie it is satisfied, factory to the Metropolitan Magistrate of the Judicial Magistrate First Class that there is a likelihood that some kind of violence will take place, because many of the complaint or the application will contain the fear, apprehension of the aggrieved person that future some kind of violence can take place in the domestic relationship. So then what will happen? Then in these cases where the fear is apparent, very so real, so then in that case, the Metropolitan Magistrate may grant an ex parte order on the basis of affidavit, sole affidavit, mean oath under the which is certified by the oath commissioner or notary public. So that non-judicial stamp paper affidavit they will give. So this is sufficient to pass that ex parte order if prima facie it appears like there is a likelihood of commission of some of the violence. So this is the provision. Section 23 talks about um, under any section like order can be of section 18, 19, 20, 21 or 22 of this act. So it can be like custodial order, it can be monetary order, it can be protection order. So it can vary, but ex parte order the court can issue under section 23 under the DB Act. And also the court to give free of cost copies. So it is kind of duty obligatory on the part of court of metropolitan magistrate or the judicial magistrate first class, which is competent court to pass the orders, directions, consider the application, because in whose local jurisdiction there is allegation that domestic violation has happened in the domestic relationship. So, so while doing that, so police officer in charge of the police station where this incident is there, so he has a like right to receive. Also, some service provider has right to receive that free of cost like copy of the orders. Protection officer also, so that they will be like able to function. So, if the service provider has registered domestic incident report, that means all service provider they have not said. If the service provider which has filed domestic incident report on the basis of which that grievance of the aggrieved person has been taken by this honorable court, and service provider has a right to have order or copy also. So other suits and proceedings are there, because there can be other reliefs. Um, okay, because there are many forms. Because this is the matter which falls under the personal laws also. If both parties are Hindu, Hindu Marriage Act will apply to them. Then, if Hindu Marriage Act is there, the competent court is district court. So, under the Hindu Marriage Act, the civil court will take their matter. Also, there is now Family Courts Act of 1984, which has created specialized acts where the principal judge mm, of the family court is the presiding officer. Another family court, like whole structure is created under the act. So also there are other criminal courts also there, because offenses in marriage there is a separate chapter in Indian Penal Code. So many of the offenses are happening in the marriage, and also special and local laws like Dowry Prohibition Act is there. This act, DB Act is there. So many, because it's related to causing the physical injury. So many of the Indian Penal Code offenses can also be attracted. So in the criminal court also, these kind of proceeding can uh, run. And if so, any relief available under this may also be sought in any legal proceeding. So one cannot say that the Metropolitan Magistrate who is competent under DB Act only can actually, if application under the DB Act only made, he can pass such an order. But any magistrate of the civil court I said Hindu Marriage Act is there, if the family court judge is there, or the criminal court mean any court of metropolitan magistrate of the local area, so competent court can issue any of the order given in this act, Protection of Women from Domestic Violence Act. This provision can be custody, monetary relief, or it can happen like protection orders. So this any court is competent out of those orders. And if any proceeding in any legal, criminal, civil proceedings or the family court itself, some relief has been obtained. And under the clause 3 of section 26, the aggrieved person is duty bound to inform the metropolitan magistrate under this act, who is considering the application on domestic incident report by the protection officer, service provider, or the complaint of the person, or through police. So the aggrieved person is duty bound to inform that what all relief was given by civil court, what all relief was given by the family court, what all relief was given by the criminal court in the matter connected to those respondent and the aggrieved person. So law is very clear with regard to jurisdiction of the court. This court of metropolitan magistrate, there's court of judicial magistrate of the first class. If the area is city, metropolitan city, then metropolitan magistrate within local limits of which three things. So person aggrieved means the aggrieved person permanently or temporarily is residing or carrying any kind of business, trade, occupation, or is employed there. So in this areas metropolitan magistrate who is also or the judicial magistrate first class, this application under this act can be filed. Also, the respondent is residing or carrying on business or the employed there also that can be done. Also, the cause of action has accrued, mean violation has happened, this domestic violation has happened in that area, which can be like not the place where the respondent reside, nor neither the place of respondent reside, nor the place where the aggrieved person reside or does any business. That also areas local magistrate where the cause of action has accrued. That means where the information complaint originated from that incident. So that area where such domestic violence incident has happened can also be a competent court, the court of judicial magistrate first class of that area, or the if it is a metropolitan area, metropolitan magistrate will be competent to try the offences under this Protection of Women from Domestic Violence Act. And what is the procedure in that act? So that all proceeding under sections shall be governed by the provision of CRPC. So they have given particularly section. So criminal procedure code will be uh, like applicable, and also court also can lay down its own procedure for disposal of application. So that is also given in section 28. And appeals also, because every decision of the court of judicial magistrate first class or the metropolitan magistrate is appealable under the act. So section 29 talks about there shall lies an appeal to court of session. That means because metropolitan magistrate court or judicial magistrate first class is deciding disposing of the application and of the aggrieved person against the respondent. So appeal will lie to court of session within 30 days. So there is a period of limitation given from the date on which the order may be served by the magistrate. Okay, magistrate court has made available the order in which date, from that to the 30 days plus 30 days on aggrieved person or the respondent, and as the case may be, whichever is later, or serving is late or 30 days are late, whatever is late will be applicable. Okay. So then there are certain chapter 5 talks about miscellaneous provisions. So there are certain provisions under the act which are designated as the miscellaneous. These are like the protection officer, member of the service provider to be public servant, because we know that there is Indian Penal Code is there. So section 21 of the Indian Penal Code talks about who is public servant. So, and this act has clarified that those protection officer appointed by the state governments are the public servant for the purpose of IPC. And there are member of the service provider. That means any member of the NGO has been given recognition to file domestic incident report by the state government, or any member of that service provider will be deemed as a public servant. So all rule applicable to the public servant will apply automatically to them, like good faith principle. So then they said in elaborately in section 30 that protection officer of the member of the service provider, when he is acting in good faith as per the provision of this act or any rule made under this act. So rule we'll discuss in some other chapter. Sorry, part of this video, and also orders made there under shall be taken, or orders mean custody order, protection order, monetary relief. All these are order, residence order. So that all order are there. So these all shall be okay while they are acting in doing these all things. So they will be deemed as a public servant, as I told under section 21 of the IPC. And there is also penalty provision for breach of protection order by the respondent. If the respondent breaches your protection order given by the Metropolitan Magistrate, so what is the consequence? Section 31 talks about a breach of protection officer or protection order or the interim protection order by the respondent shall be an offense. So which may extend to 1 year or with fine, and fine can go to the extent of 25,000 as per the act. And also the offences will be tried by the magistrate who has passed that order. So it is convenient because the fact of the case will be very clear to the metropolitan magistrate, learned judicial magistrate first class, whatever the case may be. So he will be knowing. So trial will by him or her where it has been caused. So the framing of charge is there. Like CRPC has provision, criminal procedure code of framing of the charge in any trial. So, so what will happen then in under this act, Protection of Women from Domestic Violence Act, if Metropolitan Magistrate or the Judicial Magistrate first class has to frame a charge, so may also frame a charge. So there is no restriction for the Metropolitan Magistrate or Judicial Magistrate first class. While framing charges under this section's provision of domestic violence, the Metropolitan Magistrate or the Judicial Magistrate first class can also frame a charge under Section 498 capital A of the Indian Penal Code, which is, as I referred, this is cruelty by husband or relatives. So any kind of physical, so various kinds are there in the act. So so framing of the charge is allowed, and also there are other provisions of the Indian Penal Code also. So offense relating to marriage or grievous hurt, what kind of injury it is. So that all provision of the Indian Penal Code can be charges can be framed by the competent judicial magistrate first class or metropolitan magistrate. And also there are other offences under the special and local laws like Dowry Prohibition Act. So under that also the Metropolitan Magistrate has power to frame charges. And if the facts are disclosing of commission of an offence. So if the fact, so what is fact? Indian evidence has clearly given what is fact. If the fact of the case are revealing that, okay, are revealing that these kind of offences not only under the Domestic Violence Act, but under some of the section of the Indian Penal Code, some of the section of the Dowry Prohibition Act, or any other provision in the Indian Penal Code or special and local laws has taken place. And specifically, they have given like Section 498, capital A of the IPC, cruelty by the husband and relative. So the magistrate has competency to try. So that is what is coming. Also, there is a cognizance wise also Section 32 talks about that. The offense under Section 31 of breaching of the protection order will be so. What will be it? We consider for that purpose state government. Okay, so sorry, this provision is more related to the cognizance of offense committed by protection officer. So when the sorry, section 32, I'll come again. So with regard to cognizance and proof, say that it will be cognizable and non-bailable offense of breach of protection order as per the first schedule of the CRPC. Cognizable mean section 154. FIR can be launched. Okay, non-bailable. So bail is the exclusive bail and bond provision will apply, particularly section 437 then. Okay, so then penalty for not discharging duty of protection officer. So there are certain provisions with regard to protection officer not discharging the duty. So failing and the refusing anything. Okay, duty has to be given by the magistrate competent or without sufficient cause. The cause is not justifiable. So it is not uh, it is not reasonable. So the punishment can go to 1 year or 25,000 rupees or both. Is discretion is given to the learned magistrate. And also cognizance of offences. If some of the protection officer commits some of the offences, what the act says that previous sanction of the state government has to be obtained before taking action against the protection officer. So because there has to be protection of the action taken in good faith, and sanction is further like ensure that there is a approval of the government. Okay. And then there is act not in derogation of other law. That means so okay, the provision of the act shall be in addition. So uh, one cannot say that it is nullifying some of the provision already there in IPC and other thing. It will be in addition to that. So because we want to further protect the women's uh, or aggrieved person against the domestic violence. Okay, the power of central governments to make rules are there. So under that rules are made. So in coming part, I will be focusing on the what are the rules made under the act by the government. So like qualification and experience of the protection officer, they can specify, and they can specify the term and condition of the service condition of the protection officer, and domestic incident report, how it will be filed, what will be performa, and application also has to be made in which format, forms and formula, and how when the complaint is filed, which way. A service provider has to be given license. So what is the format performer they have to apply for that? What all is needed also the rule making power of central government has. Also there is a registration of service provider provision is there, and also if rules are made within the 30 days, it has to be placed before the house. That all is there, and, which concludes the Act of 2015 DB Act. Now I will, in coming video, I will focus on the rules.